Hi, my name is Lorraine Lancaster and I'm a partner and head of real estate here at Paul Robinson. I'm here to answer the question, where do leaseholders stand in relation to claiming compensation from another leaseholder when they have caused damage to their flat? In the first instance, we would look at statute because there is an obligation under statute for the leaseholder of the other property to ensure that there is no nuisance or trespass caused in relation to your occupation of your property. So if, for example, there is a leak coming from their flat and that's causing damage to your flat, we would be able to argue that there has been a trespass or a nuisance which has caused damage, and you may then be entitled to take the step of making an application to the court for an injunction to prevent that continuing trespass or nuisance from occurring. Once the issue has been rectified by the injunction being granted and the damage ceasing, we can then also look at like time to claim damages for the disruption that has been caused to your occupation of the property, which is primarily as a result of damage caused to your flat. It may not be necessary for proceedings to be issued, and we do try in all circumstances to resolve the matter before we go to court. However, you do have that option to make the application to the court if it is necessary. There may also, however, be an obligation under the lease for the leaseholder not to cause any damage to your property, again using comparable or mirror wording to the nuisance and trespass provisions. So you may be able to make a claim under the lease itself, and that would also enable you to make a claim for damages. Invariably, what we try to do is we make both applications at like time to ensure that your position is protected. If the damage was stopped before you make a claim to the court, but we are still having difficulties in recovering the compensation for the damages caused, you can issue proceedings purely for a debt claim, and that would be in the small claims court if the debt is under £10,000, or in a standard procedure if it's over £10,000. If the debt is under £10,000, however, you do not have the ability to recover your legal costs, but over £10,000 we can make a claim for those to be paid as well. If it is the case that the leaseholder of the property is subletting their property to a tenant and it is the tenant that has caused the damage to your property, then this may complicate matters because you won't have a claim directly as against the occupier of the property because they are not subject to the same provisions under the lease. You can, however, issue proceedings against them under statute, and you can also take steps of joining in the actual leaseholder of the property so that they are also a party, because they may then have an obligation to you even though the damage has not been caused by them directly. If you do have any queries, do feel free to give us a call.